Contented Media presents Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, an original podcast series with Mark Hunter and Arthur Van Pelt.
Hello and welcome to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, and part 10 of our COPA vs. Wright series. Actually part 17, including our bonus episodes and coverage during the trial, but we're not boasting. This episode tackles Craig Wright's long-awaited appeal of Justice Miller's ruling, the one that many of his die-hard fans have been saying he was playing for all along. Trust me, it's been worth it. With me, as ever, to dissect Wright's mad ramblings is Arthur Van Pelt. Arthur, are you ready to dive back into the COPA case again?
Oh, yes, sir. I'm pumped and ready as always, Mark. Well, okay, on the other hand, to be fair, I was slowly moving away from this whole BSV and Craig Wright thing, as it is perfectly clear now to the world, and the world minus a little fan club of believers that is, of course, but Craig Wright is not Satoshi Nakamoto and BSV is not Bitcoin. So basically my job is done after 5 years, except for one thing. I've said for many years that Craig Wright will go to jail, and that didn't happen so far, so it remains a fascinating story to follow for me, these last chapters of Craig's downfall in the Bitcoin arena. Will he leave this arena in handcuffs or not? No, so this appeal of him in the COPA case is strongly related to this question. So, let's go, Mark.
Yep, indeed. Let's get cracking. Those with half-decent memories will remember that in March this year, Justice Miller ruled from the bench that Craig Wright had as much to do with the creation of Bitcoin as he did the retractable dog lead. This was followed by an injunction in July that prevented Wright from litigating based on the idea that he was Bitcoin's creator, Satoshi Nakamoto. This, for those who didn't know who they were dealing with, appeared to be the end of the matter. Some of us, however, know better. COPA's law firm, Bird & Bird, tried to serve Wright with the injunction on July 19th, alongside his lawyers, Shoesmiths, but the emails to Wright, sent to 2 email addresses they had successfully reached him on 2 months previously, bounced back. This led them to assume that Wright, ever the mature respecter of process of law, had blocked their domain. Arthur, what did Bird & Bird do to get round this?
Yeah, that's the beauty of an anecdote again, Mark. What they say is, we therefore took steps to register a new Gmail account and served Dr. Wright through that new account on the 22nd of July in 2024, which is this year, a copy of which is enclosed with his letter. Our suspicions above were apparently confirmed as the emails from that new Gmail account were not rejected by Dr. Wright's addresses, even though they were in identical terms to the July 19 email. Now, so enough time has now passed without these messages being rejected to confirm this suspicion. Had delivery failed, we would expect to have been notified within this time. This therefore appears to be a good indication that Dr. Wright is seeking to frustrate service on him. Now, and that makes it clear that indeed Craig Wright was trying to fool the system.
Yes, definitely. Bird & Bird also had concerns over Wright's place of residence. Shoesmiths told them that Wright was still living at his palatial 7-bedroom mansion in Surrey, but when the law firm for the Bitcoin developers, who are also involved in the COPA case, McFarlane's, tried to serve Wright at this address, they were told he no longer lived there. Bird & Bird looked online and found the property available to rent for a mere £12,500 per month, which they took as another clear attempt by Wright to avoid service. Bird & Bird also took issue with the injunction notice Wright had placed on his S. Tominaga Twitter page, saying that it failed to meet some of the conditions set out by Justice Miller, and also that Wright hadn't posted the notice on his Slack forum. Bird & Bird signed off with a warning that Wright could be in contempt of court if he didn't comply with the terms of the injunction by July 29th. Wright, meanwhile, was busy insisting that, despite being castrated by COPA, he was not giving up the fight, promising to carry on his battle to have BSV anointed as the real Bitcoin, even if he wasn't allowed to do it via his failed Satoshi claim. He also planned to appeal the ruling, which he did on August 9th, under the name Reverend Dr. Craig Stephen Wright, with the filing and supplementary evidence clocking in at a stunning 561 pages. The filing, as one defendant told us, appeared to be substantially written by ChatGPT and was full of every kind of hallucination you might imagine, including fake case law and imagined witnesses. Wright was told to cut this down, which he did to a more manageable 63 pages. Given what was left in, one cannot imagine what was cut out. Wright included new evidence to support his Satoshi claim, and, indeed, introduced witnesses that were either ignored for the COPA trial or weren't used. This included affidavits from Kerry and Jones, nChain's patent advisor, which Wright said could be crucial in demonstrating the consistency and methodological approach of Dr. Wright in his inventive processes. Stefan Savannah, Wright's long-term associate, which supports the collaborative nature of the inventive processes involving Dr. Wright, and Wright's man for all occasions, Dennis Mayaka, who provided an affidavit which Wright said was pivotal in refuting allegations of document fabrication, including convincing evidence that Mayaka was genuinely behind the Papanema emails. And who wouldn't want to see that? Wright also included evidence of perjury by COPA's witnesses, including Zuko Wilcox O'Hearn and Marty Malmy, who Wright said have not only lied under oath but have also colluded to protect their financial interests in BTC, arguing that their significant financial conflicts of interest and bias were not adequately challenged during the trial. So that's Wright's barristers under the bus as well. Wright also cited some forensic analysis that wasn't heard during the COPA trial. Detailed forensic analyses conducted by Dr. Wright's experts, including Peter Bryant, provide compelling evidence of the authenticity of some of the documents presented by Dr. Wright. These analyses address and refute the claims of forgery and manipulation made by COPA. The exclusion of such critical expert evidence from the trial has resulted in a significant miscarriage of justice. Arthur, what do we know of this Bryant report?
Well, initially not that much, as it was never released between the court filings that COPA put in their public Dropbox, but what we do know is that Craig Wright referred to material from the Bryant report in his witness statement, known as Wright number 11, but after COPA's objections, quote, it wasn't pursued as evidence of fact. And this is a quote from Craig Orr, which is a King's Counsel member of Craig Wright's counsel back then. And Justice Mellor's May 2024 ruling, we see the name of Bryant again. Dr. Plex and Mr. Lynch agreed with Mr. Madden on these issues in their respective joint reports. Even the report of Mr. Bryant, which Dr. Wright applied to adduce at a late stage during trial before promptly abandoning the attempt, did not support Dr. Wright's accounts on these matters.
But we never saw any contents of the report, did we? It's been mentioned obliquely. It seems like Craig Wright tried to get it in and then withdrew the request.
Yeah, that's it.
Wright's complaints continued. He argued that the court had prevented him from acting as his own expert witness, which he said deprived the court of valuable insights directly relevant to the case. Sure. He added that there had been misinterpretation and selective consideration of key evidence and testimonies, and procedural irregularities and instances of judicial bias, including inconsistent application of evidence standards and a failure to accommodate his autism, in the form of refusal to allow written communication and inadequate provision of breaks. It must be remembered that not once during or after the trial did Wright complain about the conditions, even when he came back on the stand at the end of the trial. Wright also said in his opening remarks that he had gathered evidence of document tampering and misrepresentation by COPA and substantial evidence indicating that Dr. Wright's computers were hacked by Christian Ager Hansen. None of this evidence was included in the appeal filing. Wright's demands were not small. He wanted the verdict vacated and a definitive ruling in his favour, or, if that wasn't up for grabs, a retrial, with, presumably, Wright defending himself. While the appeal was pending, he wanted a stay of the injunction, which would allow him to file lawsuits based on his Satoshi claim, as well as an independent expert to review the technical aspects of Bitcoin, including hashcash, proof-of-work systems, and the distinctions between integer and floating point operations. This expert, Wright said, must be genuinely independent, with no ties to COPA or its associated entities. Specifically, Professor Micklejohn, due to her deep interconnected ties with this industry and connections to individuals linked to COPA, cannot be considered independent and should, therefore, be excluded from consideration as the appointed expert. Arthur, what were Professor Meiklejohn's connections to COPA?
Yeah. This is also, again, such a beautiful anecdote of how this all works in the BSV realm. Yeah, you're not going to believe this, Mark. Because in their desperate search for fictional conspiracies, the BSV community figured something out with an old photo, a photo from 2015, as far as we know. But at least from the era before Craig Wright was even in the picture as an incompetent Satoshi candidate. Now, there was this tweet on October the 10th of this year, 2024, and that was done by an individual called Timecoiner, and that's his nick on Twitter. If we look at this tweet, we see a photo indeed of a rather big table, and we see roughly between 15 and 20 people sitting on those table with a lot of names that we still recognize today. For example, there is Nick Szabo, there is Peter Todd, there is Greg Maxwell, but also on that table is this Meiklejohn lady. So this Timecoiner is saying in his tweet, who is the lady in the top left corner? I feel like I've seen her in a recent court case. This tweet ended up on Reddit in the Bitcoin Cash SV community, and that's the hardcore BSV fans community on Reddit. And a Reddit user called Deadbeat said this about the Timecoiner tweet. It's very telling how the BSV cult is looking at these things. Yep, she committed perjury. She misrepresented herself as an independent expert. Her testimony is effectively invalidated. I always thought Dr. Bitcoin and AVP, that's me, Arthur van Pelt, were much too confident in COPA winning the case. This is now being exposed that they have not only manipulated the court, but they've
Have we?
We have, yes, we have.
We have the power.
But they have committed outright crimes. And what is now on trial is the veracity of the entire UK system of jurisprudence.
I didn't mean for things to get that bad. I'm so sorry.
Yes, me too. And I'm actually getting a bit scared that I might expect the police from England on the door any minute now. What he is further saying is this is not just a matter of a few bad actors like Madden, Kristen Ager Hansen and Meiklejohn, but the entire law firm of Bird & Bird and perhaps Judge Meller as well.
Shut up.
This is turning out to be a sting operation by Craig and the White Hats.
Oh my God.
Crazy. Okay, now yeah. Anyway, Craig Wright saw that tweet of Timecoiner, and I think one day later he retweeted that photo, the tweet with the photo, and he said, the presence of Sarah Meiklejohn at the 2015 gathering with BTC Core members. And again, I cannot stop repeating that. BTC Core is a fictional thing that Craig Wright has made up. It does not exist. It's not a legal or whatever entity. It's not a partnership of anything. That is just a name that Craig Wright made up. But he says that this gathering with BTC Core members directly undermines her position as an independent expert. She has testified under oath that she has had no dealings with BTC Core. That name was again never mentioned. But anyway, yet this image clearly evidences her association with the group during a critical time for Bitcoin's development. Such evidence is significant in challenging the credibility of her statements, suggesting a potential bias that conflicts with her claims of independence. The implication is that she cannot maintain an objective stance if she has been involved with those she now claims to be independent from. This directly affects the weight and reliability of her expert testimony. If her independence is central to her role in legal proceedings, this photograph serves as a contradiction to her sworn statements, raising serious questions about her impartiality and integrity. This is how it ended up in his COPA appeal, and it's pretty funny when you think of it, because in 2015, remember this was 2015, this is 9 years ago, the Bitcoin community was still so small, so of course it was easy to meet anyone everywhere and end up having a dinner together to share the Bitcoin experience. But does that suddenly make someone not independent anymore? Or perhaps it's better to say, is it expected that every independent Bitcoin person is not allowed to meet anyone anymore? So I'm sure that the judges, the appeal judges, will look at this with a giggle and a smile on their face, Mark.
Yeah, I think they will. And also, on the subject of independent witnesses, let's not forget that Craig's independent witness was Zeeming Gao. And how independent was he?
Not at all. He has been showcasing his fandom for Craig Wright quite a few times on the internet, in articles and in many tweets, and always defending against all odds every now and then, defending Craig's position. So. Yeah.
You don't get to have it both ways. Like you can't claim one is not independent while your guy is like just doing everything he can to back you up. It's just crazy.
Yeah, exactly.
Wright reserved particular opprobrium for Adam Back, with criticism of Back, his work, his testimony, his alleged ties to COPA, and his motives taking up 20 of Wright's 63 pages. Wright wanted a whole host of internal and external communications from COPA, Blockstream, and other involved parties related to their coordinated efforts against Dr. Wright to be presented in court, including Back's personal emails and DMs. Wright's rationale was interesting. These documents are likely to contain evidence of bias, collusion, and lack of independence, particularly in relation to the involvement of Dr. Adam Back. Full disclosure is essential to ensure that all material facts are before the court and that justice is served. Concerning Back, Wright wanted the court to exclude or limit the weight of Dr. Adam Back's testimony due to demonstrated conflicts of interest and misrepresentations. But it went further. Wright wanted Back re-examined in order to reassess the credibility and reliability, with specific attention to his involvement with COPA and the accuracy of his technical claims. Arthur, why has Craig Wright got such a bee in his bonnet about Adam Back?
Yeah, I think that Craig Wright is just very jealous with Adam Back, because Adam Back is mentioned in the Bitcoin white paper with his 2002 Hashcash paper as an inspirational source for Satoshi Nakamoto. And meanwhile, Adam Back is also the CEO of a pretty successful Bitcoin infrastructure builder called Blockstream. They are doing almost everything from developing Bitcoin source code to developing on the Liquid sidechain. They have developed a block explorer. They are running Bitcoin satellites all over the world. They set up Bitcoin mining farms. They have mobile mining containers. And of course, they also built pretty solid hardware wallets. So yeah, this is all stuff that Craig Wright never managed to set up successfully himself. Mm-hmm. Instead, he bankrupted handfuls of Bitcoin and Bitcoin-related companies in his Bitcoin era since 2013, especially in Australia. And I bring back in memory the Hotwire group of companies. Mm-hmm. But also more recent, the companies related to BSV, like Enchain, Tal, and BSV Foundation. They are not doing well either currently. Mm-hmm. That is what we learned in the last few months. Mm-hmm. But it's probably another story for another day, Mark.
Yeah, I think so, yeah. Also, if Craig Wright gets his way, which I think he almost certainly won't, this would mean him being the one doing the questioning of people like Adam Back. This is starting to sound like an excuse for him to just vent his spleen in a legal setting over his Bitcoin claims, seeing as he didn't get the chance at trial, isn't it?
Yeah, something like that, I guess. His hatred for everyone with some importance involved in the Bitcoin industry goes pretty deep, because they, rightfully get all the attention, and he doesn't. The only attention that he gets is for his lies, his fraud, his forgeries, and his legal bullying.
Wright's evidence of Back's misdemeanors was also interesting. Wright claimed that COPA was set up to target him personally, with his evidence being that Blockstream joined COPA since at least March 2021, mere weeks before COPA sued him. This isn't true. Blockstream was a founding member of COPA in 2020 and watched as Wright threatened COPA and one of its members, Square, with legal action in January 2021 if they didn't take down the Bitcoin white paper. When Wright refused COPA's request to show proof that he was Satoshi to back up his demand, COPA did what Wright had been asking for months and sued him, ensuring that the Satoshi issue would be settled in court. And we all know what happened there. Wright claimed that Blockstream initiated communications with other industry players following the filing of patent applications by Dr. Wright, none of which he could produce as evidence, and claimed that Blockstream infringed his patents in an attempt to undermine his contributions to Bitcoin. Wright's other evidence of Back's perjury were rants about the use of Hashcash and ECDSA in Bitcoin, which came with pages and pages of code. Arthur, this is more your domain. What was Wright trying to say with this code?
Yeah, that's quite a few pages with things that I will not repeat as a whole, of course, here. That's not so interesting for most of our listeners. But what he did here is he spends a handful of pages out of the 63 pages that he filed on the Bitcoin code. And yeah, here he is pretending to be a Bitcoin expert. That he never was and never will be, but he's giving it a try. For example, he mentioned the tokens generated by Hashcash is specific to a single purpose, in this case sending an email, and cannot be transferred or reused in other contexts. Well, not that this is remotely interesting or relevant, because it is not about being literally the same, but about being the same in spirit and design. And that's where Adam Back's Hashcash has been inspiring to Satoshi Nakamoto. And meanwhile, Craig Wright completely fails to impress with his grasping at straws that he is doing here. And actually, it's even worse, because at some point he states that, don't laugh, Bitcoin's proof-of-work system developed by Craig Wright, Satoshi Nakamoto, I still have to burp a little bit and can't help throwing up in the back of my mouth a little when I read this stuff. Oh man. Anyway, but he says that developed by Craig Wright is designed to secure the Bitcoin network by requiring miners to solve a cryptographic puzzle. And the tokens generated by Bitcoin's proof of work are the blocks themselves, which include transactions and can be transferred as part of the blockchain.
I'm not a Bitcoiner, as you know, but even I've never heard it described like that.
No, never. Anyway, there's a lot more to say about this, but it's all rather boring code stuff where Craig is trying to put salt on little snails to try score points in front of the appeal judges. But in the meantime, he's totally missing the point. It's not about Hashcash being literally used in Bitcoin. It's about the Hashcash project having been helpful in the thought process of Satoshi Nakamoto while he was developing Bitcoin.
In his summary of Back's alleged misdemeanors, Wright claimed that the suggestion that Hashcash was implemented in Bitcoin was not only incorrect, but appears to be strategically aligned with his involvement in COPA, adding Back's deep involvement with COPA and his technical expertise make it highly unlikely that this testimony was a simple mistake. Instead, it seems to be a deliberate attempt to mislead the court and the public regarding the origins of Bitcoin's proof-of-work system. Wright then used a whole new section entitled The Misrepresentation and Deception by Adam Back, which, you may not be surprised to hear, covered largely the same ground yet again, alleging that Back, while not Satoshi Nakamoto, has allowed and even encouraged the misconception that he could be Bitcoin's creator. To that point, I'll just read out a few unrelated tweets. Adam Back, May 6th, 2024. I am not Satoshi. Adam Back, April 14th, 2024. I'm not Satoshi. Not me. Adam Back, February 29th, 2024. I'm not Satoshi, of course. Usual emphatic disclaimer. Adam Back, February 26th, 2024. I'm not Satoshi. Adam Back, December the 11th, 2023. I'm not Satoshi. Adam Back, December the 6th, 2023. I am not Satoshi. In fact, Adam Back has denied being Satoshi on average twice a month in the past 2 years on Twitter alone, but Wright seems to have ignored this trifling point. Wright brought in Blockstream's development of SegWit and the Lightning Network as proof of its skullduggery, alleging that Back's encouragement of the misconception that he might be Satoshi Nakamoto constitutes a serious misrepresentation. Wright, of course, couldn't produce any evidence of this so-called encouragement by Back, despite detailing it over 3 pages. Arthur, Craig Wright must know he's wrong here because he couldn't find one example to back up his case, not even a fake one. So it's not even worth me asking you what's going on in his mind here, is it?
Mark, if we both got a Satoshi for every time that Craig Wright is lying, he's misrepresenting, he's misdirecting, he is spitting half-truth, and He changes the true course of history and thinks, I think we would both be Satoshi millionaires. So I have no idea what's on his mind when he's trying to sell stories like these. Stories that are so easily and effortlessly debunked by someone who spends a few seconds doing due diligence. I think this stuff is for the gullible, for the BSV cult, to kick the can further down the road once more. That is my educated guess, Mark.
Mm-hmm. Now, Craig Wright ended his appeal with a 6-page discussion on integer use in proof of work, using more code to outline his case. Arthur, what was he trying to say here?
Yeah, Craig Wright, I think, well, it's quite sure for me at least. He still can't live with the fact that Adam Back is his superior when it comes to Bitcoin tech and code. So Craig tries a rather incompetent rebuttal in front of the appeal judges, who will not be impressed, I'm pretty sure, especially when it is not countered by COPA's side. But he's still trying. What he is saying is, during the trial, Adam Back, a key witness, repeatedly claimed that Bitcoin's proof of work involved floating point arithmetic. Despite his extensive technical expertise, he misrepresented the fundamental technical design of Bitcoin. Adam Back's statements were not merely incorrect, they were misleading, given his knowledge of cryptography and software development. This appending provides an exhaustive technical analysis of the original Bitcoin codebase, clearly demonstrating that Bitcoin proof-of-work algorithm uses only integer arithmetic, thus proving that Adam Back's testimony was false. Now, to go into this a little bit more, Craig's issue is with integers and floating point numbers, obviously. So what follows in his filing is pages full of code mixed with Craig attempts to explain the difference between integers, which are nothing more than whole numbers like 1, 2, and 3 basically, and floating point numbers, which are numbers with decimals, like, for example, 1.25, 2.6, or 3.141, and numbers like that. So far, Craig is entertaining the appeal judges in the correct way. Presuming his further argument is also correct and relevant, that is, but guess what, Mark? Craig's explanation is wrong, as usual, and basically irrelevant, because it is based on incomplete information that he pulls from the Bitcoin white paper and instead from the actual code that Satoshi created. And to cut a long story short, Adam Back knew correctly that Bitcoin is using an arithmetic comparison with and he calls it during trial, a kind of floating point, expressing the proof of work target. Now, I will not go too deep in this. Who is really interested in this subject, I would like to refer to my article in February 2024, this year. I did on my Medium page an article how Adam Back and Martin Malmy killed Craig Wright's hope of ever winning the COPA case, and it can be found on mylegacykit.medium.com, and in there it is explained in every fine detail why Craig Wright and CoinGeek, I went back to that article to check it, but indeed also CoinGeek tried to debunk it, but they failed, and why they are incorrect. And really a piece for the code crunchers, and I would advise to the listeners to go read it.
At the conclusion of this section of the filing, Wright seemed to get a little confused and thought he was the judge, setting out a post-trial order, stating, "The court hereby recognises that the developers involved in the BTC core claim are, in fact, operating a partnership under English law. The court declares that the Crypto Open Patent Alliance, COPA, operates as a sham structure designed to shield its members from legal liability while allowing them to pursue litigation against Dr. Craig Stephen Wright. The proceedings are hereby amended to reflect the court's recognition of the BTC core partnership and sham nature of COPA. All relevant parties involved in the partnership are held accountable under the appropriate legal framework, and their actions and the development of Bitcoin Core are subject to legal and regulatory scrutiny." Wright started the next section by repeating the exact same claims in the proper format, arguing that COPA serves as a litigation shield for its members, particularly those involved in Bitcoin Core development. He then made a claim that was about as hypocritical as they come. COPA's structure allows these members to pursue aggressive litigation strategies against Dr. Wright while maintaining a degree of separation that protects them from direct liability, thereby avoiding the full spectrum of legal risks typically associated with such litigation. Arthur, this is coming from the man who is hidden behind his wife and his family and a bunch of companies and trusts, including the Tulip Trust, Tulip Trading Limited, 2 flavours of Wright International Investments, and who still owes $143 million to W&K and about £400,000 to Hodler. Is he seriously complaining about COPA members separating themselves from legal ramifications?
Pure projection, Mark.
Yes, yeah, I think you're probably right there. Wright then went into detail about the so-called strategic collaboration between the 122 plus members of his alleged cabal, which is where the champagne passing off case comes into it, claiming that COPA's resources and legal protections enable BTC Core's developers to operate with impunity. For supporting evidence of Blockstream's collusion to cripple Bitcoin on behalf of its investors, Wright included links to 2 news stories, one from Nasdaq.com and one from crypto news outlet The Block, neither of which exist, not even on the Wayback Machine. Wright then detailed his allegations that Chaincode Labs was designed to allow Bitcoin Core developers to dominate Bitcoin development, providing links to 3 more online articles as supporting evidence, again, none of which exist. Wright's evidence that COPA was a sham organisation aimed at shielding Bitcoin Core members from legal action was equally as compelling, again citing 3 more phantom articles, while his evidence that donations to these groups were strategic investments was even more voluminous, although just as lacking in insight. Of the 10 articles and news stories he cited, again, none existed, with Wright even using a domain for BitMEX research that has never held any content. 2 more phantom news stories backed up Wright's claim that Blockstream, Chaincode Labs and COPA was involved in a partnership, meaning that the supportive evidence of all Wright's claims simply does not exist. We don't have the experience or knowledge to examine the case law Wright cited, but it's hard not to look past a few hundred prompts in a certain AI program. Arthur, I'm confused. Let's say for a moment that there is an underhand collaboration between these 100 entities. How does that impact Craig Wright submitting hundreds of forgeries and then repeatedly lying in the witness box?
Yeah, of course it doesn't, Mark. Even if this fictional partnership BTC Core exists, it doesn't. It has no relationship to Craig Wright lying in court and incompetently forging evidence before and during the lawsuit.
Yeah. And reading through this, it seems that Craig Wright has mistaken allegations for evidence. He lays out all these claims as if they themselves are the evidence, with the supporting evidence being these news stories and articles that have never been written. If you make a claim of a mass conspiracy, you can't just use your argument as evidence.
No, of course you cannot. Like you're saying correctly, these are only unsubstantiated allegations.
Yeah.
And the appeal judges, if it ever comes that far, which is highly unlikely in my opinion, but they will treat those allegations appropriately and they will ignore them, I'm pretty sure.
Craig Wright then wasted more pages regurgitating the same arguments, repeating complaints 3 and sometimes 4 times, putting a conclusion within a conclusion, and formatting the whole thing like a man whose enter key only works 50% of the time. He then included a page on further ASD diagnosis that he received from one Simon Baron Cohen. Arthur, we've come across this guy before, haven't we?
Yeah, Mark, we have, actually. First, let's make it clear to the listener what Craig is stating in this appeal document, because it's quite something. So I will use that whole quote, what he is claiming, because then it makes it way more understandable what he is trying to do with this thing. I am autistic and have been assessed using the Autism Spectrum Quotient, the AQ test, developed by Simon Baron Cohen. My score of 36 out of 40 on this test indicates significant autistic traits. This score highlights several areas of difficulty. Now, and then he mentions social skills and attention switching and hyperfocus, that he is having an extremely heightened focus on detail, that his verbal communication is extremely poor, he claims, and in contrast, he has a very strong written communication skill, And about his imagination, he says, I tend to focus on specific interests and may find it challenging to engage in imaginative activities or understand abstract concepts. Now, due to these traits, verbal communication in high-stress environments like court hearings can be particularly challenging for me, and to accommodate my needs and ensure effective participation, I request the following adjustments. Written communication as much as possible, breaks, allowing for breaks during proceedings to manage stress and avoid becoming overwhelmed, and these adjustments will help ensure that I can participate fairly and effectively in the hearing. End of quote. But then we dive into this for a bit, of course. In 2023, we find in a witness statement of Philip Shirell, who was the head of COPA's council, the mentioning of this Cohen person. And here is a telling quote from that era filed just before the COPA trial. This is by Philip Shirell. In the final draft report of Professor Baron Cohen, dated the 5th of October 2021, so that's 2 years earlier, in relation to the question of adaptations of the trial, Professor Baron Cohen states at paragraph 1 that, in my opinion, Craig is fit to plead. He has the ability to effectively participate in a trial. That is quite a different story than Craig Wright is trying to sell
just a bit
in recent days. And then we noticed that our friend and patent attorney David Pearce, he went the extra mile and he inquired Cohen a bit more based on the case that Craig Wright is mentioning in his appeal document. And his surprising, but of course unpleasant for Craig Wright, results were posted on Twitter inside a bit longer tweet storm. And I'll read the relevant part of the tweet storm. Quite interesting. Wright claims that the case of Grant Murray and Anor from 2017 supports his case for the use of remote hearings as a means of ensuring access to justice for vulnerable parties. Surprisingly, this case does exist. Oh yeah, in the rest of the tweet storm, he finds out that Craig Wright is mentioning cases who do not exist. They were hallucinated by ChatGPT. It was so crazy.
Brilliant.
Yeah, so brilliant. The reason a correct citation has been used this time is most likely because it is one in which Professor Simon Baron Cohen was involved in. It relates to a murder conviction in which later evidence of autism of one of the applicants was submitted on appeal. Baron Cohen was brought in to diagnose one of the applicants, Mr. Henry, as being autistic. BC obliged, which is Baron Cohen obliged and provided the diagnosis, which had apparently been previously overlooked. The court was, however, having none of this and found that it would not have affected the trial or outcome, even if it had been known before, and there was no basis for saying that this fresh evidence changed anything. In relation to Wright's case, citing this seems very odd, given that it definitely does not support his request for a remote hearing due to autism, but also because it raises serious doubts about Baron Cohen's diagnosis of Wright himself. Oops.
Yeah, I think it's fair to say Craig Wright just added that citation in without reading it at all, didn't he?
I think that is for a lot of this stuff. I mean, how he produced thousands and thousands of pages of stuff that he tried to file, and then he was forced to bring it back to a more sizable piece of junk. And but you do not produce such a thing by yourself. He claims to be very high productive, that he is very a workaholic, that he is in his sleep listening to book readings, and he can read I don't know, dozens of books per day if he wants. It's all crazy stuff, but of course it's not true. And in this case, when he is trying when he filed this stuff, and it was thousands and thousands of pages, it was all created by ChatGPT, an artificial intelligence tool that is helping, that can be very helpful in creating this stuff, because you can just give it orders and it will try to create a rather neat filing. But if you do not check it, if you do not do diligence, if you not read it, and if you do not check all the links that it is trying to create for you, then you will end up filing complete nonsense. And that's what happened, in fact, here. There were cases being mentioned that did not exist. There's even evidence being recreated that did not exist. And crazy stuff.
Bird & Bird wrote to Wright 2 weeks after his appeal filing to make certain requests and provide you with certain information. The first was to note that Wright tried to serve Bird & Bird through an email address that didn't exist, rather than the one his various law firms would have been using for the past 3.5 years, and asked him to confirm that he had removed the block on their domain to his Gmail account. It also noted that the address Wright had proffered as his residence, 483 Green Lanes, London, was in fact that of a secretarial service company used by anyone who wanted to pay for it. It even features on the International Consortium of Investigative Journalists website as used by companies involved in illegal offshore practices. Oh, the irony. Wright responded the next day with a 3-page whinge about Bird & Bird's conduct, complaining, "I have carefully reviewed your recent correspondence and found its tone to be accusatory and lacking the professional courtesy that is essential in legal discourse. I wish to make it clear that I expect to be treated with the same level of respect and professionalism that I extend to others. My background, which includes law degrees and multiple doctorates, equips me to engage in detailed and substantive discussions." Wright spent the next 2 paragraphs using case law to back up the importance of professional communications, before noting that he would not stoop to Bird & Bird's level, issuing a warning for them in the process. "Despite your tone of correspondence, I will maintain a higher standard of professionalism in my responses. However, I must emphasize that I will not hesitate to bring any inappropriate or unprofessional conduct to the attention of the court. It is crucial that our interactions adhere to the standards expected in legal proceedings, and I expect all communications to reflect this." Wright claimed that he had not intentionally blocked Bird & Bird's emails, responding in a manner reminiscent of his time on the witness stand during the COPA trial. "I use a commercial version of Google Workspace, which enforces strict security protocols, including ARC, DMARC, and other systems to protect the domain. Any issues you have encountered in delivering emails to me are due to misconfigurations on your end, not from any block on my part." Wright added that he had magnanimously whitelisted Bird & Bird's domain, so he could now accept their emails, noting, "I've had to create exceptions within my security systems in order to do so." These are the security systems, remember, that have been hacked by upwards of a dozen individuals and entities over the years, so it can't have been that onerous a task. Wright then discussed an apparent allegation that he had changed his email address to avoid service. "I must emphasize that these false accusations are not only unfounded but also pointless in this instance. While they may have had some rhetorical effect in other contexts, such as with shoesmiths, they will not achieve the same result here. These attempts to create a misleading narrative will not be accepted, and I will ensure that they are brought to the court's attention. I remind you of the requirements under the civil procedure rules for conduct during litigation, and any further baseless accusations will be noted and addressed accordingly." Arthur, unless I'm missing something, Bird & Bird didn't actually accuse him of changing his email address, did they?
No. They accused Craig Wright of willingly trying to avoid service. And we touched on this earlier in this episode, remember?
So where did he get this idea that they accused him of changing his email address? Has he just made that up?
Yeah, that must be.
Because they don't mention it anywhere. I read that and I thought, they didn't accuse him of that. And I thought, I didn't know if you'd spotted something, but no, they never accused him of that. It's crazy.
Yeah, exactly.
Wright added that use of a secretarial services address was perfectly within UK law before reminding Bird & Bird that he suffers from autism, which, while limiting his verbal skills, rather ironically meant that, when it comes to written communications, I operate at an extremely high level. Well, ChatGPT does. Craig Wright filed his champagne passing off case on the 10th of October, leading to Bird & Bird serving him with contempt of court papers 8 days later, alleging that it represented a breach of the injunction and warning that if it wasn't scrapped by the 22nd of October, COPA would initiate contempt of court proceedings. Arthur, which areas in particular did Bird & Bird highlight?
Yeah, they mentioned a few things and they put it in a nice bullet list. So just a quickie, but Bird is referring to what Craig Wright is stating and saying in his filing and what is wrong with it. You were responsible for the acts of Satoshi Nakamoto in uploading the Bitcoin white paper to bitcoin.org and publishing the link to the paper on the cryptography mailing list on October the 31st of 2008, which is a breach of paragraph 1 and 1b and 1a of the order. So that was one. You own goodwill in the name Bitcoin, which is a breach of paragraph 1a of the order. The third bullet is stating you own database rights in the Bitcoin blockchain, which is a breach of paragraph 1a of the order. And you own copyright in unspecified aspects of the Bitcoin system, and that is a breach of paragraph 1a of the order. And I say 1a, there are sub paragraphs of paragraph 1a, but it's a bit too much to mention them all. But the main message is that Craig Wright has been mentioning several things about goodwill, about database rights, about copyright, about being Satoshi Nakamoto, literally when it was acts that Satoshi Nakamoto has been doing and uploading the Bitcoin white paper and things like that. That is clearly, several breaches.
Bird added that the Champagne case amounted to an abusive process, warning Wright that COPA was minded to press for contempt whether he withdrew it or not, although it suggested that the court might look favourably on withdrawal when it came to sanctions. COPA then brought home the seriousness of the issue to Wright. Please be in no doubt that, given the outrageous nature of the new claim, our clients will urge the court to impose the severest sanctions available. We should also put you on notice that our clients will be applying for a general civil restraint order against you based on your conduct in bringing claims to date and what is reasonably to be expected in the future. Arthur, what is a general civil restraint order in this context?
Well, that is, in short, that is a court order intended to prevent vexatious litigation. In the United Kingdom, courts have the means of escalating the sanctions against the litigant who makes applications to the court that are totally without merit. So there are three types of civil restraint orders that they can use. The limited, the extended and the general, and they have different scopes of application. And here is mentioned a general civil restraint order, which was, I read on Wikipedia, that's formally called a BAMG order. But it's a restraint order for a maximum of 3 years for any and all proceedings in the High Court or specific county courts in the United Kingdom.
Bird also warned Wright that the charges were extremely serious and your actions may lead you to be imprisoned, advising him to get legal advice. Wright replied to this the same day, asserting, "Your letter dated 18th of October 2024 is riddled with factual inaccuracies, legal misstatements and unprofessional threats, calling COPA's allegations a blatant misrepresentation of both the facts and the law surrounding the new claim I have filed." Wright added that Bird's letter was marked by deliberate inaccuracies and inappropriate threats and was not only an attempt to intimidate but an outright abusive process. Arthur, I'm not sure about you, but that description sums up about every letter I've ever seen from Ontier when they were representing Craig Wright.
You got it, Mark. You nailed it. It's what the interested reader of Craig's material will notice time and time again. Craig is a master in projection. Accuse the other party of all the things that you're actually performing yourself, and that is what Craig is doing all the time.
Wright also challenged your continued efforts to manipulate the situation, particularly by obfuscating the relationship between SquareUp, one of the Champagne defendants, and BTC Core will not succeed. Wright reiterated the claims made in the Champagne passing off filing over the 122 plus members of BTC Core, accusing Bird of being complicit, calling its continued denial of SquareUp's liability not only legally unsound, but also a clear attempt to evade the consequences of your client's actions. He added that Bird's threats of contempt of court are entirely unfounded and represent a clear misuse of legal process designed to intimidate. What was he saying about unprofessional conduct? In his defence, Wright argued that the injunction relating to his Satoshi claim was wholly distinct from the issues raised in my Champagne claim, which does not engage with or overlap any aspect of the matters covered by the injunction, and issued a rebuke that, in the light of his mammoth appeal filing, is nothing but crystallised hypocrisy. You have provided no evidence whatsoever to support your assertion that my Champagne claim constitutes such a breach. In fact, your allegations are devoid of any substantive basis and are nothing more than an attempt to coerce me into discontinuing a legitimate legal action. This coercive tactic is wholly inappropriate and will not succeed. Wright complained, again, that the nature of Bird and Bird's letter amounted to a breach of professional standards, adding, "Severity of this misconduct cannot be understated," and warned that Bird and Bird's actions may lead to serious professional repercussions. If COPA didn't withdraw its threats and rectify the misrepresentations contained within your letter by the 22nd of October, Wright warned that he would have no choice but to initiate further legal action, including, but not limited to, seeking costs for your misuse of the court process. Bird and Bird partner Philip Sherrill submitted a 53-page affidavit supporting COPA's request to file contempt charges against Wright on October the 23rd, summarising that Wright seeks to challenge Mr. Justice Miller's factual conclusion that he is not the person who created Bitcoin. Sherrill pointed to extracts from Wright's blogs as to his understanding of the seriousness of disobeying court instructions, including the following illuminating paragraph. "If you don't like this, welcome to the real world. Too bad. This is not a matter of arguing with me, it is pure existence and the world you live in. If you don't like it, vote against it. At least you live in a democracy." He also pointed to Wright's tweets from his S. Tominaga account that he planned to sidestep the constraints of the High Court's prior judgment with his Champagne case, and noted that Wright had neither complied with their request to discontinue the case or reported Bird and Bird for their threatening letters. Sherrill also noted that Wright's at Dr. C.S. Wright account had withdrawn the injunction notice at least 4 days before he was allowed to do so. Arthur, does this explain why Wright had a couple of rants about no longer controlling that account?
Yeah, I think so. It's very plausible that that's why he was ranting about it, of course.
Sherrill outlined the specifics of COPA's case before noting that Harcus Parker replaced Shoesmiths as Wright's representatives on July the 16th, only for Wright to then file everything himself. Harcus Parker confirmed to Bird and Bird on October the 21st that it was no longer representing him. Sherrill then commented on Wright's emails, including a brilliant little nugget that dispenses with Wright's arguments that he is not using ChatGPT to write them. Since Dr. Wright began corresponding on his own behalf, it struck us early on that his documents appeared to be written in the style of ChatGPT. However, on one occasion when corresponding with the court, he appeared to accidentally copy and paste not only the output from ChatGPT, but also the prompt he had submitted. Sherrill added that neither COPA nor Bird and Bird particularly cared how Wright composed his emails. But, Arthur, what was Craig Wright's response to this?
Yeah, this is another hilarious anecdote from Monty Python's, Craig Wright's Flying Circus again, Mark. Let's dive right into it with some quotes from Sherrill's recent October the 23rd filing. Mm-hmm. It is, of course, entirely for Dr. Wright to choose how to compose his own correspondence, and that is not a point we have taken against him, and we did not even advert to what was obviously a simple copy-pasting error. Nevertheless, when he realized his mistake, Dr. Wright proceeded to write a series of letters and emails to the court claiming that we, or COPA, had hacked into his emails.
Oh, not again.
Yes, sir.
Oh, give it up, man.
Sherrill continues, this is of course pure fantasy, of the same kind that Dr. Wright retreated to at the main trial. He protested that his correspondence should not be taken to be authentic unless he also filed it on the court's e-filing system, and that he would obtain identified certificate services to authenticate his emails themselves. However, he did not do so, nor did he adjust his mode of correspondence in the way he suggested. Since then, his correspondence, and including that which he has also tweeted, has continued to be by email. So it is clear that Dr. Wright is not above claiming that his email correspondence has been interfered with in order to escape the consequences of his correspondence with us and the court.
I just don't get it. Just say, yep, I use ChatGPT for my emails. Whoops, sorry, left some words in there. No one cares. It is so much worse to try and claim that COPA or the law firm representing them has hacked you, again without evidence. It's really not a bad thing to admit you use ChatGPT. Why does he go to these extremes? I don't understand it.
No, I don't either. I think it comes with being a narcissistic and compulsive liar type of person like he is. When you can, when possible, you try to put yourself in the victim role. And that is what he is doing a lot when it comes to this hacking excuse. When he doesn't know an excuse rather quickly, he comes up with, I was hacked. Sorry, not my fault.
Yeah.
I was hacked.
It's part of the blaming other people complex, isn't it?
Yeah, that's it.
Cheryl also recorded Wright's movements abroad through his CS Tominaga Twitter account, noting that it is clearly owned and operated by him. Cheryl alleged that Wright appears to be itinerant and, although he is able to travel, appears to be avoiding this jurisdiction, and had refused to provide a true residential address. Cheryl therefore sought permission to serve Wright through his email account as well as over email before concluding that Wright's new lawsuit was already causing defendants to incur legal fees, adding that the individuals and companies within the groups supposedly targeted by the new claim will have suffered the distress and inconvenience of knowing or suspecting that Dr. Wright is attempting to sue them for astronomical sums of money. He then summarised the last 5 years of Craig Wright's life. Dr. Wright has a long history of pursuing highly aggressive campaigns of litigation against those in the cryptocurrency community whom he perceives as his adversaries. As we covered in our update earlier this month, SquareUp requested that the Champagne case be stayed pending the outcome of the contempt trial, which would likely see the Champagne case dismissed were Wright to lose. In response, Wright called for all hearings on the matter to be held remotely or, amazingly, on paper, my autism, that evidence from interveners be included to support his claim, and that he be allowed to add his mammoth list of BTC core members into the contempt bundle. Arthur, what did Cheryl say to this?
Allow me to read paragraph 55 for you of COPA's so-called contempt skeleton. For the court's information, COPA's position on those will be as follows. A. The remote hearings application. COPA will resist the application for a blanket rule that Dr. Wright need never attend a hearing in person, including for the reasons given in section 6 above. However, COPA accepts that remote or hybrid attendance may be appropriate for short procedural hearings as with this CMC. The interveners application, that's under B, COPA does not really understand this application. If the new claim were to proceed, Dr. Wright would be able to serve factual evidence on any issues of fact in the proceedings and could seek to persuade the court to permit expert evidence in particular disciplines from appropriate experts. But if the purpose of the application is to enable other individuals to enter the proceedings without a proper joinder application, then it should be rejected. And number C, the last one, the alleged partners application. This application should be straightforward. Rejected. There is no such legal entity as BTC Core, there you go, and no such partnership as Dr. Wright has alleged. This application is an attempt to add a huge number of further defendants on a false basis. And that's, if you ask me, completely true.
Yeah, I think it's fair to say they weren't fans of what he wanted.
No, exactly.
Cheryl added that Wright's evidence should be submitted by late November with the aim of holding the contempt hearing in December, adding that Wright could attend the November hearing remotely, but should attend the December hearing in person, for reasons we discussed in our update earlier this month. Cheryl noted, tellingly, that Wright would attempt to invoke his ASD condition to avoid personal attendance, a claim he called spurious, adding his real motivation is a wish to evade the consequences of his contempt. Arthur, we saw that during the short session earlier this month, didn't we?
You mean the fact that Craig Wright attended the court session with a video link from Asia, presumably Thailand, where he fled to after he lost the COPA case?
Yes, indeed.
Yeah, indeed. Then that is what we saw indeed, yeah.
That's everything included in the publicly available sections of Craig Wright's appeal, but what we haven't told you about is the other part of it. Alongside this 63-page filing, Wright included some 2,000 pages of additional information, around 1,000 of which is extracts from the courtroom testimony. Sadly, however, we don't yet know what variation of literary slurry he has managed to fill these pages with, although from this filing we get a pretty good idea. For this reason, we don't expect a decision on this appeal to come anytime soon, unless the judges are just going to sweep it all into the dustbin in one go. Arthur, this filing is indicative of someone who doesn't have legal representation. It's not clear whether this decision to represent himself is through choice, having despaired at the performance of all his previous law firms, or if this is a financial decision. Where do you sit on that?
I lean very much towards that it is financially related. Craig Wright is, as far as we know, not being sponsored anymore by his backer Calvin Ayre, but he probably sold his I think it's more than probably he sold his Enchain shares to Calvin Ayre last year, and he then took the money and ran, and that's probably the only money he has now. That is likely in a few millions running still. But he wouldn't want to spend that by the boatloads when he thinks that he can do court cases alone with the help of ChatGPT, of course.
It's a lot cheaper. It doesn't get you what you want, but it is a lot cheaper.
Yes.
So, before we leave this topic, it's worth noting a glaring omission in this filing, Patrick Madden. Now, we all remember Madden's reports being dismissed by Wright supporters who claim that Bird wrote the reports and Madden just signed off on them, which was denied by Justice Mellor completely. But this was supposed to be a major part of Craig Wright's appeal, and we also had Craig Wright on the stand criticising Madden's methodology dozens, if not hundreds of times, accusing him of being an amateur forensics analyst who wouldn't know a shared Citrix environment if one ambushed him on a country lane. And yet, for all that, Patrick Madden's name doesn't feature once across these 63 pages, which suggests that Wright can find no objection to them. Arthur, we don't know what's contained in these other thousands of pages, but what does the fact that Madden's name is not mentioned here say about his true feelings about the evidence that Madden presented?
I went back to the documents, not only this filing, but also the response to this filing from COPA. And indeed, Madden is never mentioned. And it was, I found it quite cool that you figured it out, because it's true. So, but I think we can make a more than educated guess that, of course, Craig Wright, because he knows his own evidence, his hundreds of forgeries, and they were completely destroyed adequately by Madden. And let's also not forget that almost all findings of Madden were seconded by Craig's own forensic experts. Yeah, so he will not be able to recover from that during an appeal. And there's not a snowflake's chance in hell that the appeal judges will look differently at Craig's forgeries and come to drastically different conclusions as that Justice Mellor already did. So yeah, you're right. The true feelings of Craig Wright about his own evidence is that he lost it.
So our listeners might be glad to know that's it for this episode. As I said, we have no idea when this appeal ruling will drop, but it's unlikely to be before Craig Wright's contempt of court hearing, which takes place on December the 18th and 19th. Justice Mellor, again, will decide after a hearing on November the 26th whether Craig Wright will have to attend in person, which we all hope he will, meaning we could be in for a very nice Christmas present indeed. Arthur, when this appeal ruling finally drops, is there anything in particular you're looking forward to, or just the whole thing?
Like I said in the start of this episode, my main interest is when, it's not even if anymore for me, but when will Craig Wright go to jail? When will the bomb drop on his head? Is it already this year? Is it next year? Is it during the appeal procedure, the contempt of court, the champagne passing off, or the CPS procedure? I mean, there's so much playing currently again. Most of it, I see most of it fizzle out early next year or maybe this year already, and that only the CPS case, the Crown Prosecution Service case, is continuing. But yeah, it's still sort of exciting what's going on now.
If, as we expect, this appeal is rejected, do you see him taking it all the way to the Supreme Court, or do you think that's where the money will maybe be diverted towards other projects, other lawsuits? What's left?
He doesn't give up easily, so I can see it happen that he is looking for every angle in every courtroom that he can try and see where he can go with it. So
yeah,
we're not finished with him.
Set your ChatGPT to stun everyone. This could take some time. Arthur, thank you so much for spending the time to go through this with me again. I don't know when we get the ruling, but whenever we do, I'm looking forward to sharing it with you.
Yes, same here. See you next time.
Speak to you soon.
Yes, sir. Bye-bye.
Thank you for listening to this episode of Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Don't forget to subscribe to the show on your podcast platform of choice to get these episodes the moment they drop. And if you enjoyed what you heard, we'd really appreciate a star rating and even a review to help us get this out to as many people as possible. Our monthly bonus episodes are available to download from our website for a small consideration. And if you'd like to access all these bonus episodes, plus these monthly updates a few days early and other goodies, you can do so by becoming a Dr. Bitcoin supporter. See the details in the show notes for information on how to do this, or head to our website, drbitcoinpod.com. That's drbitcoinpod.com. You can also follow us on Twitter at drbitcoinpod, and you can email us at drbitcoinpod@gmail.com. That's drbitcoinpod@gmail.com. Thanks very much for listening, and we'll speak to you again soon.
You've been listening to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Written by Mark Hunter, with additional material by Arthur Van Pelt. Editing and production by Mark Hunter. This has been a Contented Media production.